In New Jersey, divorce proceedings can often trigger a complex equitable distribution, meaning a division of the assets. If you're a business owner in New Jersey, it's important to protect your business by clearly defining what is business and separate property and making sure that it's not treated as marital property, which could be subject to division between and transfer to your spouse. Essentially, it's important to keep things very clear and clean. Any business action should be done under a formally recognized business entity, LLC, or a professional corporation. It's important for you to make sure that you're using accounts from your business for business purposes and not your personal accounts for business purposes, because you don't want to commingle. Essentially, you don't want to mix up business income with your personal monies in any personal accounts. Any transfers from your business account to your personal account should be clearly marked and memorialized. Essentially, you want to make sure that any income generated from your business that you're using is treated either as payroll or as a W-2 salary. You want to make sure that your articles of incorporation, which is your business formation documents, clearly show who the shareholders are. You want to essentially make sure that nothing from your business ends up in your personal accounts, in your marital accounts, without being memorialized as either payroll or any other transfer for that purpose. You want to make sure that things are clean. You want to make sure that there's no chance that a court can determine that that income from your business belongs to your spouse. If you're a business owner, you likely have a demanding work schedule. However, you still want to be involved in your child's life. It's important in terms of creating any kind of parenting arrangement that realistic expectations are clearly communicated to your co-parent before the issue might come up. It's important to always inform your co-parent of any work or travel arrangements that you are required to do, especially if they might fall during a parenting visitation or your scheduled time with your child as early in advance. It's always best to be considerate because your co-parent also has their own obligations and expectations. So collaborative communication will always help make sure that that co-parenting dynamic is as healthy as possible, because at the end of the day, you two share a common goal, and that's to raise a child that has contact with both parents and spends enough time with each parent to maintain that bond, as well as to go to their extracurricular activities and to essentially not disrupt their schedule too much. So an open line of communication, especially when things come up, is highly important and will save you a lot of headache. If you're a business owner, there's likely a lot of nuanced issues in your life that an appropriate attorney that's understanding of those will be able to prepare you for and to help you before any potential issues might come up. It's important to choose an attorney that's aware of how businesses are formed, can analyze a shareholder or operation agreement correctly, that can determine how certain income is a business income versus a marital income, because those are important when a court is determining and assigning child support amounts. You want to make sure that also your attorney is understanding of the demands of your work schedule and is, with that understanding, is able to help you create a realistic co-parenting agreement that both parties will be able to follow. If you have questions regarding protecting any licenses or your career during your divorce proceedings, please don't hesitate to contact us at Next Chapter Family Law.